Hello guys, my name is Gauri Bandre. I'm an intern at LEXIS and Company. My topic for today's discussion is attempt. So in today's discussion, we'll see what is attempt, how is it different from that of preparation, and what are the punishments given under law, etc. So to start with, let us first understand what is inchoate crimes. So inchoate crimes is basically a preliminary stage of a crime. Now, inchoate crimes can be classified into two types. One is abetment and second is attempt. Abetment is basically instigation, aiding, or conspiracy. And attempt is not as such specifically defined under IPC, but Section 511 covers offences of attempt. So, to understand attempt, let us first understand what are the basic stage of committing a crime. First of which is mens rea, second is preparation, third is attempt, and the final stage is commission of the crime. Okay, so attempt is one step ahead of preparation and one step behind of commission. Under Indian law, attempt is a punishable offense. Even if you try to do something towards committing a crime, it is considered to be an offense under law. Now, an essential of a crime is what? One, there should be a human. Second, mens rea. Third, actus rea. And last is injury. Okay. Now, in case of attempt, it is not always necessary and important that there should be injury to a person. Injury in what sense? Injury in reputation, harm towards body or mental health, or etc. It is not always necessary. In case of attempt, there will be reputation or harm to anybody's body or health. Because see, let's take an example where I am trying to kill B. Okay, I know for a fact that before sleeping he always take 1 glass of milk. I put poison in his drink, but one fine day he just skips the milk and he sleeps any which ways. But next fine morning, his cat drinks that milk and dies in the process. Now here, even if there was no injury or harm to B, still it is offense, right? Because I tried to kill B, it was not successful, that is a different thing, but I tried to kill him. So by this we can conclude that not always injury is necessary in attempt. Now next question comes, how can we determine where does preparation ends and attempt begins? For that, there are approximately 5 tests which are given under law to determine the seriousness of crime or what punishment should be given under attempt. First of which is proximity test. So what is proximity test? In proximity test, will determine how close the defendant or the accused was in committing a crime. Now for an example, if I hit B with a rod, okay, now I hit him with all my force, but somehow B survived out of that. This was a situation where B was lucky enough to get saved out of this situation. Here again, law will determine how close I was in committing this crime. I tried with all my force to kill B, but somehow he survived out of that. Second is impossibility test. So what is impossibility test? Now, in case we know that something is impossible to happen, okay, now here we can take an example of a thief trying to steal from an empty pocket. If B is trying to steal something from my wallet, but I know that there is nothing in my wallet, but he doesn't know that. Now in this case, it was impossible for B to steal something from me, but he tried to attempt. Third is social danger test. Now in this case, the seriousness of the crime is determined. Now in case of crime against women, which are very grievous and very serious in nature, they have much larger consequences of the society. In this case, we will determine what was the social danger of the attempt of the crime. Fourth is res ipsa loquitur. Now what does that mean? Things speaks for itself. In case where it was very clear enough and there is no, the facts and circumstances are enough to prove that the attempt was very successful and it was towards the commission of the crime, then in this case it will be punishable under law, because it was very clear and things are speaking for itself that yes, he tried to attempt and he was one step ahead of the preparation and towards committing the crime, then it will be punishable under law. Is the doctrine of repentance. Now, in this case, the doctrine says a person cannot be charged for an attempt if he is in a position to give up or abandon his plan out of his own accord after the formulation of mens rea. Here we can take an example where I am trying to kill B, okay, and in preparation towards killing B, I go and buy a poison from a medical shop. But after coming home, somehow I changed my mind and I don't feel like killing B anymore. Now here, even if I had the mens rea, still I didn't act towards it, right? I somehow changed my mind. So this is again determined under the consequences, and it is very subjective in nature. It will change from the circumstances. These were few of the tests through which we can determine the seriousness of the attempt and what punishment should be given under the attempt. Punishment under attempt are broadly classified into 4 types. One is same punishment for attempt and commission. Now, example of this is section 121, which talks about attempt to wage war against your country. Now, even if you don't wage war or you try to wage war, it is serious enough and it is still the same. So here, even if you attempt to do so, it will be considered as an offense as it has been already committed. Second is section 124. Third is section 125, etc. And second is separate punishment for attempt and for actually committing a crime. Example of which is to commit murder or attempt to commit theft. Actually committing a murder and attempting to commit a murder is very different and they have different consequences under law. Third is only attempt is punishable and no crime. So the example of this is suicide and only suicide, because in this case only attempt to suicide can be punished. If the person has already committed suicide, you can't punish the person because he has already died. So yes, this is only the exception under this punishment. Fourth is if no specific provision provided for attempt, then it will be punished under section 511 of IPC. Now, what if there is no prerequisite punishment given under law? Now, in this case, we will see what is the punishment for committing the offense of the crime. If it is, for an example, 20 years, then we will give half of it, okay? Now 10 years will be attempt for the crime. So this is how we determine what are the valid punishments that should be given under or attempt of committing an offense, and what is attempt, and how it is different from preparation. I hope that you understood some of it, and if you like my video, do subscribe to this channel. Thank you.